Joining us now on the phone is Scott Erskine, one of the lawyers on the team of the gyms. He's the managing partner of the Erskine law firm. Scott, thank you for being with us today.
Thanks for having me.
So last night the decision comes in about 9 o'clock. Going back a little bit further, U.S. District Court Judge Paul Maloney issues an injunction that allows gyms to reopen. It was supposed to happen today, 12:01 a.m. They get their affairs in order. They're preparing to reopen cautiously as the governor plans to appeal the ruling. All is well. Then at 9 o'clock last night, the rug is pulled out from under them with the ruling from the three judges at the Sixth Circuit Court of the U.S., Sixth Circuit Court of Appeals of the U.S. Take us through that process. What was the justification from the panel that was argued in agreeing with the governor that gyms must remain closed as the governor continues her appeal?
Well, first of all, there was no argument other than briefing. The governor they filed their emergency motion on Tuesday around noon, and at 2:30, while I was at a water park with my kids, we got a call from the Sixth Circuit asking us to have a response brief filed by 9 a.m. yesterday. So the Court of Appeals unfortunately didn't have the full transcript from the lower court, 90-minute oral argument, and they had to make the best decision that they could based upon briefs that my team spent the entire evening and well into the night working on. We were very disheartened to read the ruling late last night.
A quote from the panel, quote, "We sympathize deeply with the business owners and their patrons affected by the governor's order." The three judges panel then went on to say, "Crises like COVID-19 can call for quick, decisive measures to save lives, yet those measures can have extreme costs that are not often borne evenly. From your client's perspective, with all that they did to prepare the reopen, with all the business that they've already lost, what are those extreme costs on their end?"
Insolvency. We had a gym in Grand Rapids declare insolvency just yesterday. They can't hang on anymore. It's been over 14 weeks. The economic toll and the mental toll of my clients is exhausting and is immeasurable. I don't know how much longer they're going to be able to hold on. The only solace they took from that was there's been acknowledgement by the courts as to the toll that it's taken on, because quite frankly, the governor's attorneys have consistently argued in their briefing and in oral argument at the district court level that there has been no harm to the fitness industry by being closed for 14 weeks. And that's been a tough thing for my clients to hear when they still have to pay rent, they still have to pay utilities. Some of them have tried to hang on and pay staff. They've had to pay for equipment that they ordered just prior to the shutdown. Some of them, equipment costs in a gym can be between $125,000 and well over $500,000. And sometimes they get financing. Well, the ones that have financing for their equipment still have to pay their monthly payment on the equipment. And for the state to consistently argue that doing all of those things while they're shuttered is not harmful to them has been really, really seemingly out of touch with reality.
From the state's perspective, arguing that this is a public health concern, and then from the gym's perspective, what have these gyms been doing to prepare to reopen safely today, as they were scheduled to do so before this ruling? What sort of regulations have they put in place, and are they ready to be open safely?
So they've been preparing, in earnest to get open. I know that if you read some comments and news articles, people talk about gyms being dirty. That's actually just not the case in 2020. Gyms are some of the cleanest establishments, even pre-COVID, that we have in this country outside of the medical field. And to add to that, my clients have gone out and purchased things such as cleaning solutions that turn regular water into ozone, which is used by the University of Michigan, the University of Minnesota, Stanford, to clean all of their facilities. And it's EPA approved and to kill COVID-19. And so they're using environmentally conscious cleaning products in most cases that won't harm their members, but that clean it on contact. And they spray down all of the equipment, the entire floor, the entire area where any gym members can go with this solution 2, 3, 4 times a day. They also provide hospital-grade wipes for members to carry with them, so that every time they go to a new piece of equipment, they can wipe it down. They've also changed the entire workout schemes at most of the gyms, or we're planning to, so that it limits the amount of equipment that a member touches. There's hand sanitizers they've all been putting up all through the studios so that members can use hand sanitizer whenever they want. They allow the members to wear masks. They make the trainers and staff members wear masks and face shields. They have gone through a lot in order to prepare for this, and they're confident they can reopen safely. They're confident they can have members maintain social distancing. The governor's executive order 2020-114 lays out the requirements for gyms in regions 6 and 8 to be open. And my clients are prepared to far exceed the requirements that the state has put on the gym owners in regions 6 and 8.
Scott Erskine with us, the managing partner of the Erskine Law Firm and one of the members of the legal council representing the gyms in their argument against the governor's ruling in this appeal, as she argues that gyms should remain closed. Judge Maloney in the previous U.S. District Court case had argued that the governor, quote, could not articulate a reason beyond the bare assertion that gyms are dangerous as rationale for keeping gyms closed going forward during this process before the next step of the My Safe Start plan. In this appeal at the Sixth Circuit Court of Appeals, was the governor's team able to put forth any elaboration on that assertion, in your opinion?
In my opinion, no. All they did, well, first of all, in the district court hearing, the oral argument, the state was unable to articulate any basis to keep gyms closed. And in their brief in front of Judge Maloney, they did have that footnote about that South Korea outbreak on February 6th before South Korea at a fitness-type dance class where there was no social distancing yet in South Korea. The virus had just hit that country, and the measures that we were going to open under, and that was that we were questioned a lot on, we're going to far exceed what happened in South Korea in February. And again, the governor didn't even argue that at the district court level. They put in a footnote of a brief and didn't bring it up in oral argument. Or if they did, they just said, well, we do have this study. And that's it. That's all they said. Everything else was, it's just dangerous. You're going to have to trust us. This is a dangerous virus, and gyms are dangerous places. And the governor kept pressing them. Do you have any evidence of that? Well, we don't need evidence. You have to. It's your job, Judge, to go through our everything and see if you can think of any reasons why gyms should be closed. And if you can, then you have to deny the plaintiff's motion for preliminary injunction. The problem is, Judge Maloney couldn't. It actually took a 3-judge panel going through everything to find that footnote and hang their hat on it, which, again, we respect the Sixth Circuit Court of Appeals, but we don't think it's fair to allow the governor to use a footnote regarding an outbreak in a foreign country before any of us knew what COVID was as their rationale to keep gyms closed. The governor keeps mentioning data and science are driving her decisions, but they brought none with them. They brought no data, no science. Despite repeated requests for any of the data or science that the governor has compiled that would keep gyms closed today in June, where we know so much more about the virus than South Korea did in February.
Scott, from a legal standpoint, what's next?
Well, my team is exhausted, so I haven't sat down with them and gone over the next steps. We're considering a motion for reconsideration in front of the Court of Appeals to point out that we don't believe that the correct legal standard was applied. And in our briefing, we weren't able to have oral argument on the issue. We argued that a heightened level of scrutiny on the governor's action needed to be applied other than rational basis. And that's simply because her executive orders aren't like legislation, which is, the case law in support of a rational basis test is mostly talking about legislation where you have two houses vote on something and then it's signed by the governor into law. And there is case law to support that executive orders that are not supported by the legislature do not deserve the same rational basis level of scrutiny. They deserved a heightened level of scrutiny. And as we all know right now, not only does our legislature in this state not support the governor's executive orders, they're suing the governor, saying that she doesn't have the statutory or constitutional authority to issue those executive orders. So that's the first thing we're considering. We're also considering an appeal to, or an application for leave to appeal to the United States Supreme Court. The problem with that is, although they are able to hear things on an emergency basis, and they did in Bush v. Gore, and they did in a church case from California a month or two ago, they don't take a lot of things on an emergency basis, and for very good reason. They're very busy. And so we don't know if that would provide the relief that my clients need to in enough time to save them from insolvency.
Scott Erskine with us from the Erskine Law Firm. He is the managing partner of Erskine Law and one of the members of the council representing gyms in their argument for reopening as the governor appeals that they should not be allowed to reopen, and currently they are not allowed to do so. Scott Erskine, anything else before we let you go today?
Yeah, it just really quickly, it's the ruling is disheartening for one other reason, and that's, my clients aren't Republicans or Democrats, or actually they're both, and they're people who help people, and my clients are, in a business that helps people with three of the top comorbidities of people that contract COVID-19, which is obesity, diabetes, and hypertension. And they also can help everyone else in this state, if they're allowed to open, that are suffering from depression, anxiety, stress. And for my clients, knowing they can help people who in the future may contract COVID-19 and help the rest of us that are, as coming out of this pandemic, are really depressed or stressed out about it, to watch the governor open so many sectors of the economy, like hookah bars, basketball camps, choir camps, lottery ticket sales, liquor stores, recreational marijuana dispensaries, all of these different businesses, and declare them safe, even though there are reported outbreaks at some of the places that she's opening, or that she's opened, and she's not closing them. But yet just to keep us closed based on an outbreak in South Korea in February is just really, really troubling for both the legal team and our clients.
Well, Scott, we thank you very much for being with us today. Obviously, you're very, very busy at the moment with this case ongoing, and hopefully we'll have some resolution to this either in the next few weeks as the governor brings us into phase 5 as is planned by July 4th as of now, or by other means, and hopefully your gyms can find some solace in that as it comes in. Thank you for being with us today, Scott Erskine.